Here we'll talk about professional negligence or medical malpractice. So the doctor is irresponsible, which leads to the injury of the patient. So absence of responsible care and skill from the doctor or the willful negligence. It can also be intentional negligence of the medical practitioner leading to the bodily injury or the death of the patient. So negligence consists of two acts. One is act of omission, another is act of commission. Commission, you are committing something. So doing something that the reasonable doctor wouldn't do under any circumstances. In the omission, you're not doing anything that a reasonable doctor would do under some circumstances. Coming to the next point, the negligence requires the patient to establish this 4Ds. So patient can only complain in the court of law that the doctor is negligent when he has this 4Ds. One is the doctor-patient relationship, another is the dereliction of duty by the doctor, the third is damage caused by the doctor, fourth is direct causation of damage by the doctor. So coming to the first one, some random person cannot come to a doctor and file a complaint against him because of his negligence. That's not possible, right? So the patient should have some relationship with the doctor. That means if the patient develops some injury or develops some condition, he goes to the doctor, he talks to them, he's consulting him regularly. There is a doctor-patient relationship. So after the consultancy, the doctor is not showing enough care to the patient. That is dereliction of the duty of the doctor. What is the duty of the doctor? The doctor should care for the patient. The doctor should use a skill to treat the patient. So that is the duty of the doctor. So if it's not showing enough care or the skill in treating the patient, that is the dereliction of the duty. And the third is damage caused by the doctor. So it can be compensable injury. That it is not too much that the patient develops some serious injury or serious damage, but it is not a minimal damage also. It's somewhere in between. So damage which can be compensated by the money is the third one. And coming to the fourth is a causal connection between violation of the care and harm complained by the doctor, which causes the direct causation of the injury. The patient comes with some small injury and doctor does something which increases the injury, which develops some other conditions which may be risking the health of the patient. So so here the doctor is directly involved in increasing the disease or increasing the risk of the disease to the patient. So this is the direct causation. So the 4Ds are: the patient should have a relationship with the doctor. That means the doctor-patient relationship must be established. And second, there is a dereliction of the duty. That means the doctor is not performing his duty properly. There is negligence on the side of the doctor, which causes the damage to the patient. And also, if there is any direct causation of the damage to the patient. Types of negligence, there are two types. One is civil, another is criminal. So in civil there is compensation, and in criminal there is imprisonment. So what happens, let's see here. So in civil, the negligence is a tort. That means it's a civil wrong. Negligence should not be done, but it can happen few times unintentionally, and it can lead to some damage to the patient, which is not much of a damage, but it is damage which requires some compensation. So let us see here. So in civil negligence, the patient brings charges of the negligence against doctor for the monetary compensation from the damages suffered by him. So what happens? The doctor is negligent for his acts, which causes the damage to the patient, and the patient comes to the court of law and files a complaint against the doctor because he has this 4Ds: doctor-patient relationship, dereliction of the duty of the doctor, which led to some damage to the patient. So he comes to the court and files a complaint against the doctor. So now here, the doctor has to pay some amount as a compensation for the damage caused by him. Usually the patient comes and files complaint against the doctor because of his civil negligence, but here the doctor can also file complaint against the patient when the patient is not paying fees. The doctor is treating the patient right, but the patient is not paying his fees. Then the doctor can come to the court and sue him for the this thing. Coming to the next point, so the doctor is somewhere responsible for the damage or the harm or the suffering of the patient. So damage is such that it is compensated by paying money. It is not too severe. It is not the death of the patient, but it is somewhere it is compensated by the money. It does not involve the legal punishment. It does not involve the IPC or CRPC. It does not involve any loss here. It just the compensation of money can be given by the doctor. So damage to the patient that can be compensated without demanding legal punishment. To be valid, the suit for negligence must be filed in the civil court within 3 years from the date of allegation. So see, there is a doctor-patient relationship and dereliction of the duty by the doctor, and the patient develops some damage or the injury. So patient has filed these allegations against the doctor that because of his negligence acts, I have to undergo this suffering. Now, from the date of allegation, within 3 years only he can file the complaint in the civil court. After 3 years, it's not valid. And if he files a complaint and the court gives some decision, he cannot go to another court and file the same complaint there for the different decision. If one decision is given, that's final. So this is called as res judicata. Coming to the criminal negligence, it is more serious than the civil because the damage is severe. It can lead to the death of the patient or any severe high risk conditions developed by the patient. So practically limited to cases where the patient has died. So here the relatives or the family members file a complaint against the doctor. Here there will be imprisonment of the doctor also. So the punishment is imprisonment. So mostly associated with drunkenness or impaired efficiency due to the usage of drugs. You can see in the movie Arjun Reddy, right? So doctor shows this gross incompetence, and just remember that scene where the doctor operates on the patient in the Arjun Reddy. You can write this line: the doctor shows gross incompetence, inattention in selection and application of remedies. He don't know what he's doing, so which puts the patient at the severe risk. That is the criminal negligence, and it is punishable under the law. Under the section 304A IPC, it deals with the criminal negligence. Whoever causes the death of the patient by doing this negligent act, not amounting to the culpable suicide. That means the Arjun Reddy is not doing it intentionally, but that means he's not amounting to culpable homicide, but he's done it because of his negligence. Should be punishable with the imprisonment up to 2 years with or without fine. So the difference between 304 and 304A is, in the 304, the doctor is doing intentional negligence. There is an intentional act of negligence. Coming to the 304A, it is a bailable offense and the doctor has not done it non-intentionally. So here the criminal negligence of Arjun Reddy comes under 304A IPC, right? And also in some cases, a physician may be sued or liable to civil and the criminal negligence both by the single act. That means he has done something by which he is filed against, that means he has to pay some compensation for his act, and also he has to undergo this imprisonment for 2 years. Like if he performs unauthorized operation on the patient, that means he is not authorized to do the operation. That means he is not skilled enough to do the operation, but still he does it because of some money or anything. In such cases, he is applicable for both criminal and civil negligence. Criminal because of assault and civil because of the damages caused for the patient. Coming to the burden of proof in case of criminal negligence lies with the patient, but in case of civil negligence, the burden of proof lies with the doctor. That means the doctor has to prove that he is not negligent, or it may be something else. The doctor has to prove here, but in case of criminal, the patient has to prove. So on the patient side, they have to prove that the negligence of the doctor led to the death of the patient. So in civil, 51% certainty of the proof is enough to file this complaint against a doctor. In case of criminal, 99% certainty is needed. That means the patient has to prove beyond a reasonable doubt. It has to be clear for the court and people being there that the doctor's negligence led to death of the patient. So in that cases, the doctor is arrested for 2 years. Examples of the medical negligence: general errors like not giving TT injection. When the patient has come with the injury, the doctor has not given TT injection. Later, the patient developed tetanus. It's an example of medical negligence. Failure to act on the radiological report, not making the right diagnosis, or failure to diagnose this myocardial infarction, or operating on the wrong side, wrong patient, retention of instruments inside the body, and in cases of failed tubectomy or failed vasectomy, which leads to unwanted pregnancies also, it is a medical negligence. Criminal abortions and inadequate treatment of the hand injuries. So when the patient comes with a fracture and the doctor ties this plaster of Paris too hard, that means it can also lead to severe problems, right? So it is one of the example. And missed foreign bodies like glasses in the hand injuries in cases of fracture. Anesthesiology, so excessive use of anesthesia can also cause many risk for the patient. So these are the examples of medical negligence. Coming to the contributory negligence, here the doctor and the patient both are responsible for the negligence. So the negligence of a patient and doctor contribute to the injury. Coming to the doctrine of comparative negligence, here the quantum of injury caused by the patient and doctor negligence is decided by the court, and according to the compensation is awarded. That means, see, here both are responsible for the negligence, right? So the court sees who is more responsible for the negligence and gives more compensation to them, right? That means they have to pay more money if they are more negligent. That is the doctrine of comparable negligence. And exceptions, the last clear chance means, in last clear chance, see, if a doctor given some drug to the patient and the patient developed some rashes and the patient did not complain to the doctor, it is his fault. Later the patient comes to the second visit to the doctor and the doctor noticed the rashes but did not do anything. Here the fault is with the doctor. So here the doctor is punishable. That means the doctor has to pay the compensation. And coming to the next point, that is avoidable consequence rule. In this case, the patient comes with some injury. The doctor do not give any TT injection or does not treat the wound, but he also asks the patient to do not contaminate it by anything. Later he goes home and keeps this Ayurvedic leaves or something like that on his injury, which lead to more of the damage. Then here the patient is negligent, the doctor is not. So the patient has to pay the amount, the doctor should cannot pay the amount. So this is about contributory negligence. The burden of proof is on the doctor, and damages will be divided between the patient and the doctor when according to the act of negligence. If only the patient is negligent, then the only patient has to pay the compensation, vice versa. So this is about negligence.